Good morning and good afternoon, depending on where you are in the country today on this Wednesday. Thank you for joining us. Privileged to be here again with Blake McKibben. If you've joined any of our previous estate planning conversations, we're thankful to have you back. And today is a very targeted and timely topic, talking about the Connelly Supreme Court ruling and how it will impact your business as a business owner. So I'll talk a little bit in a moment about what the Connelly Supreme Court case was or is, for those of you that may not be familiar with it. But our goal today is to really familiarize everybody with a few foundational points as it pertains to being a business owner. And in many cases, business owners have partners and or partnerships in those ownerships of companies and entities. And so we're going to talk a little bit about the importance of buy-sell agreements. What are they? Why are they essential to what it is you're trying to accomplish longer term? That old saying of begin with the end in mind is prevalent here as you think about buy-sell agreements. We'll talk about the funding mechanisms to carry out buy-sell agreements. We'll investigate the ruling itself, and then we'll explore some ways to avoid the Connelly treatment. As I mentioned, I'll talk about this case here in just a second to get us started. But as a reminder, here at Miracle Mile Advisors, we are committed to planning-based relationships with our clients. And so, this screen is just a friendly reminder that a lot of what we do starts with goals-based planning, which leads to goals-based investing. But really, it's the other, 7 or 8 dots that you see around this circle that are really important to that client relationship and ensuring that we're helping make solid financial decisions that are helping you achieve the outcomes that you desire. And so whether that's cash flow planning, it's budgeting, it's risk management, it's capital gains and income tax strategies, or simple balance sheet, management and or forecasting. All of these things are part of your financial life. All of them can be confusing and challenging at times. And today we're anchored in this space of wealth strategy and liquidity planning from a business ownership standpoint. And so for those of you that, loosely are familiar, forgive me for the next 30 seconds as I just highlight what the Connelly case was or is about, just for those that may not be entirely familiar. So on June 6th of this year, the Supreme Court upheld the lower court's ruling in what was called the Connelly case. And the short of the Connelly case is a situation in which two brothers, Michael and Thomas Connelly, happened to be the sole shareholders of Crown Sea Supply, a building supply corporation. And they had gone through the process of creating a buy-sell agreement so that when one of these brothers passed away, the brother that remained was able to purchase the deceased brother's shares if they so chose. In this situation, one of the brothers passed away and the other brother, Thomas, chose not to purchase those shares, which then triggered the company's obligation to redeem the life insurance policy that they had put in place on the brother Michael. And this is where it starts to get a bit complex. So the estate had reported the value of their shares at $3 million. However, the IRS valued those shares at $5.3 million. And then you had the life insurance component, proceeds, if you will, valued at nearly $900,000, all of which impacted the value for the estate. And so what we're going to talk about today is how do we ensure ourselves protections and ensuring that we don't end up in a situation where we have added tax liability should we find ourselves in a situation similar to that of Connelly, and some of the learnings that came from this case that Blake has studied intimately in his 20-some years of estate work and working with many business owners and entities. And so Blake is our resident estate attorney. For those of you who have not met Blake before, spends his time working with clients on ownership, buy-sell agreements, works in the estate trust space, reviewing wills and trust documents, and helping our clients, again, make sure that they are planning for the legacy that they intend to leave behind. And so with that, Blake, thank you again for joining us this morning, this afternoon, wherever you might be. I'll turn it over to you.
All right, thank you very much, Nate. Yeah, and as I was, thinking about this webinar, I just kept thinking about experiences that I've had in my past. So when I got out of law school, the first 7 years of my life, I was really in the weeds and working with families on buy-sell planning. So it's the intersection of estate planning and business succession planning. And so for 7 years out of law school, I flew all over the country and worked with families and gave presentations. I remember I would do presentations at little steakhouses here and there. I spoke at the Black Hill Stock Show 3 years in a row in South Dakota. I spoke at the International Pecan Growers Association. I so I didn't grow up on a farm, but both my parents grew up on a farm, and so I'm not that far removed from it. And growing up and starting practice in the Midwest, farming is a way of life, and it's something that so many families are connected to. And so what I found really rewarding is working with families to help them solve a lot of issues. And we're going to talk about these as we go through here today, but really buy-sell agreements help provide continuity and structure for the success of the business going forward, not just for the business's sake, but for your family's sake as well. I sat on a lot of kitchen tables, and there were a lot of tears that came up, because when you're talking about businesses that you put your blood, sweat, and tears into yourself, and how that impacts your family and your loved ones, and then also the people that work in your business that you depend upon, your partners, employees, and then the people that depend upon your business. If you supply, put things out in the supply chain, or if you have creditors and things like that, everyone depends upon your business. And so it's with great pleasure that I get to speak here again today on this topic. And I'm happy to work and individually with each and every one of our clients to go through and look at current plans in place, see if there's any holes that might be in there, and then work through how to make your plans better, whether it be an estate plan or a business succession plan, shareholder restriction agreement, whatever it is. And now this Connelly case that just happened, a few months back, once again, it's another one of these shots that we're like, oh my gosh, we have to go back. We have to look for something else. So there's always things that come up as time goes on that really think, oh, we've got a trigger. We've got to go back and review. Because, the implications on that case were about $1 million extra that this family had to pay in estate taxes that they weren't expecting to pay. And a lot of the families that I've ever worked with that are business owners, a lot of them are asset rich and cash poor. So anytime there's a big estate tax or something like that, you got to pay estate tax in cash, right? And so if you're asset rich and cash poor, that can lead to very bad results. So with that, we're going to really just touch the surface here today on buy-sell planning and the Connelly case. But really, I wanted to let you know that I'm happy, and I look forward to working with each of our clients to look at their financial future, their estate plan, and how that intersects, and make sure that everyone's going to be taken care of top to bottom. And so as we begin, what is a buy-sell agreement? Well, quite basically, it's a legally binding document. And what it does is it outlines the terms and the conditions under which ownership interests in a business can be bought or sold or passed on at death. Important things, right? It specifies what happens at someone's disability, at someone's death, at someone's retirement, or just wanting to sell their shares and move on and depart the business. The agreement is important, and you can go in the weeds and really drill down, but biggest thing is that it allows you to set forth how the business is to be valued at these points in time, right? At someone's death, there's a lot of grief going along. There's a lot of emotion tied up into that. The last thing that we want to do is have to negotiate, well, what's this business really worth, right? So Also, these buy-sell agreements just they prevent disputes before they even occur, right? Ensuring continuity and stability. And here's what always happens: there's a lot of chaos when a business owner dies. There's tons of chaos because the deceased owner's family, they want top dollar, and maybe they don't know the books. They don't know what the in and outs of the business, because here we're just dealing with the surviving spouse and maybe kids, and they think, hey, well, dad or mom, they were able to, afford this or that or the other, and so it must be worth so high, but maybe in reality it's not. But of course, the deceased family, they want prompt settlement. They want to move on with their life, and they want to relieve themselves of the worries of the business and the continued operation of the business. And of course, the surviving owners, they're going to want the lowest purchase price. And the most important thing, they're going to want full control. They don't want any interference from any of the heirs of the deceased partners. They want a hassle-free transfer of the assets, and they want to continue that relationship with the bankers, with their creditors, and things like that, because disaster strikes, everybody gets worried, and creditors do as well. And where if you have a buy-sell agreement in place and your creditors know about that, they've got the comfort too that, hey, something happens to this person, we're still going to have a partner that we can deal with in the future. And so why create them? Well, hey, it just provides that blueprint. But in reality, the most important thing is that when you embark upon business, when you go into a business endeavor, you want to be in business with those that you choose to be in business with, not by accident. Of course, this applies in businesses, but also this applies in your estate plan as well. Think about multiple people. If you've got a vacation home you're passing to the children, right? And one child is a neat freak and the other child is not at all. And you think, well, hey, I'm just going to give it to my kids. When I'm gone, they'll just equally share it. Well, how is that going to work? Does that neat freak child want to be owning a property with the person who's not, has different standards of care and how you use property? Absolutely not. So buy-sell agreements can help eliminate those different issues before they happen to ensure a smooth transition and continued success. So once again, going through its smooth transitions, it provides how the value is to be negotiated. It takes the negotiation out, right? That way, as we said, disaster strikes, we're not negotiating at that time with all the emotion and everything on top of it. Now, a buy-sell agreement is step one, right? Hey, we've got it set out. We've got the legal terms in place. Hey, at death, we know who has the option to buy. We know the payment terms, the price. We know all of that. But still, there's an obligation to buy. And so as we're doing the planning for how we're going to pass on this business, we also have to think about, well, hey, if I'm a business owner and my partner dies, I have the obligation to buy his or her shares from their estate or from their trust or whatever it is. I need to find out how I am going to pay for that purchase. So there's several ways to fund buy-sell agreements. Oftentimes you can go to a bank and borrow the money, right? You can go and you can save up money for that obligation. You can sell assets that you have to raise the funds, and you can use life insurance. Now, I got to be honest with you. This presentation is not designed to sell life insurance. It's not. We definitely have the capability. We've got a life insurance team and the like. But life insurance plays a huge role in funding buy-sell agreements. And we'll get, it just economically makes the most sense. Now, the Connelly case is definitely cued in on life insurance. It was life insurance and the company's life insurance that the whole case was hinged upon. And so life insurance is incredibly important and definitely something to look into. So let's just look at an example of these different funding mechanisms. Let's say, hey, we have a buy-sell agreement, which obligates me as the business owner to buy out my business partner for $1 million at my business partner's death. Okay. Well, what does that look like? So if I want to go and borrow money from a bank and get $1 million bank loan, well, $1 million bank loan, 7% interest, which that's probably pretty good. I think it's probably more, it's higher, you know, a mortgage is about 7% and business loans are typically a little bit higher. So, but anyways, if it's 7%, I have annual payments that I have to come up with after my partner's deceased, right? So I have to continue the business to help make these payments for 10 years is 142,000. So over 10 years, it's a 1.423 million that I have to come up with to make that $1 million buyout possible. Now I could also save up the money. Well, first of all, with saving money, there's a lot of variables there. If I'm saving up money, what am I going to be really risky with that? Or am I going to be really safe in my investments? But also when I save up money, I don't know what my time horizon is. But let's say you did, you knew, hey, 10 years, if this is going to be the case, I'm going to save money at 7% every year. So that means I have to save up $72,000 every year so that in 10 years, I have $1 million ready at my disposal, leaving I've got to save up 723,000. Other ways to sell assets, right? Well, if I have to sell assets to net $1 million, well, I'm probably selling appreciated assets. So I have to pay tax on that. So I actually have to sell about $1.3 million of assets in order to net my my $1 million of assets at the end of the day. Now here's the option. Here's why so many buy-sell agreements are funded with life insurance. Well, here's an apples to apples approach here. So I'm looking at, let's say that my business partner was a male, not a tobacco user, 55 years old. You know, that's where, you know, life insurance, there's a lot of variables here. Life insurance can be the best thing, can be the worst thing, but it's definitely something that's worth looking into, because in a scenario like this is a type of a policy that's a 10 pay, that I only pay into this policy for 10 years, and then it's guaranteed to be there until at least age 100. And so in this case, I'm paying policy premiums of about $19,000 a year. So in 10 years, I'm only paying about $190,000 in order to have that $1 million of death benefit if my partner dies in 10 years. Now, no one has a crystal ball. Nobody can say when we're going to die or things like that. But let's say another little wrinkle of, hey, you know what? My business partner is 55 now. We think we're going to sell this business in 10 years anyway. So let's just do something between now and that 10 years. Well, typically you do a 10-year term insurance policy. If that's the case, it's just about $1,700 a year. So over 10 years, you're about $17,000 to fund that. And so, you know, I said we're not here to sell insurance, but we're here to help our clients look at the options. And the options, when you really truly look at it, a bank loan, you're always going to be paying more than the purchase price because interest is going to come in. Yes, you can always save up money, but there's no guarantee on saving an amount, the right amount for the right amount of time. Selling assets is never great because you have the tax bill. Whereas insurance, it's painful to write the insurance premium checks, but at someone's death, you're going to have insurance money that comes in income tax free. That's there that you can use. So definitely, and at the end of the day, it might be a combination of these different mechanisms working together that'll work best for your situation. Now, so we kind of talked about why buy-sell agreements, the orderly transfer, right? Talked about funding buy-sell agreements. Let's just talk about the different types of buy-sell agreements. So I'm going to talk through each one of these and use an example along the way. So we're going to start off in talking about what's called a cross-purchase buy-sell agreement. We're going to move on and talk about an entity purchase or a stock redemption agreement. Then we'll talk about what's called a wait and see approach. Move on and talk about the one-way buy-sell agreement, which that's something that can be done with business partners, but that also can be housed in an estate plan for passing on family business to the next generation, or just family assets, like a vacation home or something like that. And then we'll talk about the hybrid entity or cross-purchase vehicle. So with that, let's start and talk about a cross-purchase agreement. So the basics of a cross-purchase agreement. Well, hold on. Before we get into this cross-purchase agreement, I just want to give a real quick primer on the idea of basis. Okay. So when you purchase something, your purchase price sets your basis in that asset. Okay. So I purchased some stock today at $10 a share. My basis is $10 a share. If the stock goes up to $100 a share and I want to sell it, well, then my basis is $10. I sell it for $100. I have to pay capital gains on the difference, right? So my basis was very low. Oftentimes with businesses, what you have into the business, what you've invested into the business, sets your basis in your business. Now, if you add to your basis by purchasing machinery or equipment or something like that for your business, that adds to your basis. But one thing that subtracts from it is when you depreciate that equipment over time. And so what I find in working with a lot of business owners is that a lot of business owners don't have a lot of basis in their business. Meaning that if they were to sell their business today, they'd have a big capital gain hit, and potentially maybe some ordinary income tax in there as well. And so before we jump into these things, I just wanted to lay that out there, right? Basis is what you have in to something, which matters when you sell it down the road. But I just wanted that little precursor. So back to the cross-purchase agreement. And so in a cross-purchase agreement, this is where each owner agrees to purchase a proportionate share of the departing owner's interest. I'll get to a specific example, but once again, typically funded by life insurance policies. And this is where you're in business with your other partners. You take out an insurance policy on each of your partners. And the idea is when that happens, then you get the proceeds, and then you use the proceeds to buy out your partners. You get some tax advantages because when you buy out your partner's shares, what you pay for those shares increases your basis and gives you that step up basis to that amount. Now, of course, this becomes a lot more difficult when there are a lot of owners, and when the owners have different, if they're in different circumstances. Like if you're looking at a life insurance policy, if there's different circumstances for each one of the business owners. So here's an example. We've got ABC Biz, owned equally in thirds by Ann, Ben, and Cal. Okay. And so where this becomes difficult is a few things. Number one, let's say that they want to do insurance here. Well, with insurance, as we said, a cross purchase means that each one of the owners is going to take out an insurance policy on the other owner. So in this case, Ann would own one policy on Ben, and Ann would also own a policy on Cal. Ben would own a policy on Ann, and Ben would own a policy on Cal, and Cal would own one on Ann and one on Ben. So as you can see, 3 owners, that's 6 life insurance policies here. So it can get a little bit more confusing as time goes on. It could add to a lot more policies. And the way that you do it is you find out the number of owners, you minus 1, and you multiply them together. And so 3 owners, you minus 1, so 3 minus 2 is 6. So if you have 4 owners, your 4 minus 1 is 3 times 4 is going to be 12 policies. 5 owners, you have 20 policies. 6 owners, 30 policies. 7 owners, 42 policies. So a cross purchase can get a little bit cumbersome in the number of life insurance policies. But also we think about this. Well, hey, what if Cal isn't in the greatest shape and maybe he's 10 years older than Ann and Ben? Well, that's not great either. But still something to look at. And we'll talk about some of the other nuances here with these other examples. But let's look at this one here. So I'm going to pick on Cal. Let's say we have a scenario here, Cal passes away. At that point in time, because Ben and Ann owned insurance policies, the insurance company is going to pay the insurance proceeds from Cal's death to Ann and Ben. Now, because this is a life insurance policy, Ann and Ben receive those proceeds income tax free. And then Ann now has the funds that Ann can turn around and purchase Cal's shares from Cal's estate or from Cal's trust. Ben has the same. And so the money goes to the estate to purchase the shares, and then the shares come back to Ann and Ben. So the result is that something happens to Cal. Well, now Ann has purchased Cal's shares. Ben has purchased Cal's shares. Now Ann and Ben are the two happy owners of this business. And on top of that, Ann's basis increased by what she purchased Cal's shares for. And Ben's basis increased as well. So that's the mechanics of a cross-purchase agreement, right? It's individual on each one of the individual owners. So it's done that way. Now we look at an entity purchase buy-sell agreement. So this one's a different way. This is where we have the business entity agrees to purchase the departing owner's interest. And so the insurance policies are owned by the business, and the transaction then is between the business and the departing owner's estate. So here's how this works. Once again, we've got ABC Biz and Ben and Cal. And so here, with an entity purchase, ABC Biz owns one policy on Ann, one policy on Ben, and one policy on Cal. Now, this also is kind of nice because if Cal was a lot older, if he wasn't insurable, well, this makes it so that Ann and Ben don't have to make up that difference, that the company itself is making up that difference. And so here's the way this functions, right? A lot more simple. Cal passes away, insurance company pays the proceeds out to ABC Biz. ABC Biz turns around, uses those proceeds, buys out Cal's shares. Cal's shares go back up into the business, and those shares essentially go back into the business and they just get eaten up by the business. So now we have the scenario, Ann and Ben now are they're 50% owners. Their ownership stake went up, but their basis in the business doesn't change at all because this was just something that occurred that they didn't, the cross purchase, they bought out the shares from Cal's estate. Here, it's just the business redeems the shares. So those shares now are eaten up by the business, and now they have a proportionate more, but their basis in the business doesn't change. Okay, so you can kind of see there's pros and cons to the cross purchase. Tax-wise, a cross purchase is the best way to go about it. But an entity purchase does kind of make sense when there's a lot of different individuals or when the insurability is different amongst all the different partners. There's a good thing. There's other ways to go about it. Now, there's another way. This is a wait and see approach. And this is a hybrid approach, combining both of the cross and entity purchase. But the way that these work is these, once again, they're legally binding agreements that they might provide the option that, hey, the first right to buy the shares of the deceased owner goes to the individual business owners. If they don't want to do it, then the company will redeem the shares. So once again, this does offer flexibility in that, and it's a legally binding agreement, but there could be a risk. Sometimes people just do a wait and see, and really, wait and see is better than nothing, right? Because hey, a deceased owner passes away, the other owners aren't negotiating with the deceased owner's surviving spouse. That is wonderful. We always want to avoid that. But if we haven't followed this up with any funding mechanisms, well, that could be a risk that we don't have the mechanism there. And so with a wait and see example, it's quite simple, right? Same scenario. Cal passes away. Well, then, hey, then it's up to Ben, Ann, and the biz as a whole to figure out, how are we going to do this? Do we want to have the business redeem? Do we want to have individuals redeem? And how are we going to come up with the money to do that? It's borrow money from a bank, or it's selling assets. And at this point, yes, you could save money up ahead of time, but after the fact, saving money is out of the question, as is obviously life insurance. So yes, wait and see is better than nothing, but it's definitely something you need to think through the funding, because yeah, the legal obligation is paramount, but funding has to happen because it's a legal obligation to purchase those shares. You got to come up with the money somehow. Now, another example I want to use is a one-way buy-sell agreement. Often this is with a single owner who wants to ensure a smooth transition. So this one, once again, hey, we want to provide the opportunity to buy at some specified event in the future. Now, this works, as I said, with family businesses, but also this can work in a different context, like passing on a vacation home or something like that. So here's my scenario for this one. Let's say we've got Gil and Mary here, and Gil owns a car dealership, Car Family LLC, owned by Gil 100%. And Gil and Mary have 3 children. Hal is not involved in the business. He graduated high school and had nothing to do with cars, hates cars, doing his own thing, right? But Tom and May have always worked in the business. They're there, they're integral pieces to the business. And part of the reason why the business has succeeded is the way it is because of Tom and May's efforts and what they've put into business. So let's take an example here. So in Gil's estate plan, so right inside of Gil's will or trust, he can lay out a buy-sell agreement, a one-way agreement. And so in his estate plan, he can spell out, hey, here's how the price is going to be determined, and here's the payment terms for Tom and May to buy out the shares, right? Now, also, Gil might say, well, you know what? This is family assets. I want to be as fair as I can to each child. So maybe I'll say that at my death, and at Mary's death, that, Tom and May can inherit more business assets, and Hal can inherit more of these other assets. So that might make that purchase price a little bit offset, because Tom and May, they're going to inherit a portion of the estate anyway. So if they already inherit a portion of the business, they have to come up with less money in the end. Now, on top of that, with a one-way buy-sell agreement, there's a lot more flexibility here too, because we're looking at essentially, in this scenario, a distribution from Gil's estate. And, there's nothing in the law that says you have to treat your kids equally at death. There is that thing that each family has to decide what's right for them, what is fair, because you don't have to be equal. Fair versus equal is a huge thing to think about, because as we look, and I've worked with families and worked with, some farmers in the past that, hey, this business is as successful as it is because of the business successors staying and working in the business. And so Gil can be more favorable to Tom and May because, hey, they helped them build it, and this is an inheritance. This doesn't have to be equal. There's nothing that has to be equal here. And so oftentimes in scenarios like this, Gil may purchase insurance in the name of his trust and name the trust as the beneficiary. And that provides some offset of the inheritance, right? That may allow Tom and May to inherit almost all the business assets, and then Hal would have some insurance proceeds that he would inherit to offset that. Now, Tom and may also purchase a life insurance policy on Gil. That way, when Gil passes away, they'll have the liquidity that they can use to buy out their brother Hal. Now, there's no right or wrong answer to this, but the wrong answer is really just waiting. You know, I've worked with, you know, there was a family I worked with that had an apple orchard, and this father had two sons, and his dream was when he died, he wanted his two sons to take on the apple orchard. And unfortunately, and as I got to know and I started working with his son that was in the business with him, I found out that the second son was addicted to drugs and he was just down the wrong path. But the kid that was involved in the business was a lot like dad, so detail oriented, type A, you know. And so what dad wanted to do was to have his kids take over this business. But if he would have just left it that way and left it at his death, it's going equally to my children, that would have run the business into the ground. Thankfully, I was able to help and work with them. And now, so you know, dad passed away several years ago. And now the one son that wanted to take over the business owns the business. And now that place, they have like they started making cider, and they're picked up, and they're national in their distribution of cider. So they went from an apple farm, which they still are an apple farm, to a destination, you know, for the fall, you know, pumpkin patch, all that kind of stuff. Come pick your apples. And then they also got into this other business as well. And so once again, at the end of the day, in estate planning and business planning, we want to be in business with those that we choose to be in business with. And I know this is a little diversion, but it's really important to start thinking about these things now, because it only gets harder as time goes on to solve some issues that may occur. So with a family like this, hey, Gil sets up in his estate plan. He creates the buy-sell so that when Gil passes away, Tom and May are able to step in, continue operating the business without Hal being there, looking over their shoulders. And Hal, like I said, is, you know, he didn't want anything to do with the business anymore. So even in the family business, passing it on to the next generation, buy-sell agreements can and should be employed to pass on in an orderly transfer. Now, I want to talk about one last vehicle, and I'm going to wrap up with Connelly and what that meant. So this last vehicle is a hybrid. So this is really trying to take the benefits of the cross-purchase agreement, namely that you get the step up in basis of what you buy, with the ease and of the entity purchase agreement, with just having individual life insurance policies. Now, the thing is with these, and I'm going to go through the examples, there's a lot more complexity that comes with this approach, but it could potentially be worth it to your family or to your business to explore this type of an option. So once again, we look here. Once again, we've got the Biz, we've got Ann, we've got Ben, we've got Cal, our three business owners. And here, Ann, Ben, and Cal, they've created this separate business entity, the Hybrid Buy-Sell LLC. So the sole purpose of this business entity is really to own policies on the lives of each of these shareholders. So as I said, we've got the cross purchase and entity purchase that's coming to play here. And so we pick on Cal again. Well, at that time, the insurance company pays the life insurance death benefit to the Hybrid Buy-Sell LLC. And then the Hybrid Buy-Sell LLC distributes those proceeds to Ann and Ben. Once again, these are life insurance proceeds. They're owners of the LLCs. These are non-taxable distributions from the insurance company to the LLC, from the LLC to Ann and Ben. And then Ann and Ben personally, this is where the cross purchase comes in. Ann and Ben now have the cash that they buy out Cal's shares from his estate or from his trust. And they come back to Ann and Ben at the end of the day. Ann and Ben are the proud owners of the business. They own 50% each, and their basis has now increased because they personally purchased purchased Cal's shares from Cal's estate. So that's the hybrid. So yes, it's more complex, but you kind of get the best of both worlds. More simplified insurance, but you also get that cross purchase, the basis increased at death. Okay, so now we've kind of gone through the different buy-sell mechanisms and how they can be structured. Let's check out this Connelly case. Now, the Connelly case impacted C corporations and S corporations. That's the first thing. It doesn't apply to everybody, but it applies to these businesses that do an entity purchase buy-sell agreement. So entity purchase is really on radar. So anytime we talk with families about entity purchase, my radar now goes up post the Connelly decision. And so here's the way it worked before the Connelly decision. So in these entity purchase, Cal passes away, insurance company pays over to the biz. The biz uses that to buy the shares from Cal's estate. Before the Connelly decision, let's say that we had $1 million buyout. Okay, if the purchase price was in the buy-sell agreement was $1 million, funded with $1 million of life insurance, then when the biz bought out Cal's shares, Cal, in his estate, for estate tax purposes, included $1 million as the buyout price. So that was what Cal's estate had to pay estate taxes, right? This is the big change. Post Connelly, that's thrown out the window. So what the Supreme Court said is that when the deceased owner's shares are to be purchased out with the life insurance death benefit also increases the value of the estate. So the Connelly family said, no. That increase of value is offset by the obligation to buy out the shares from Cal's estate. But the Supreme Court said no, that hey, there's still value in the business. And now the business has more shares, more, and actually the business has less shares because it's eating shares. So the business is actually worth that post amount. So what this adds to is that, hey, now Cal's estate must use the purchase price of the shares, so $1 million, plus his ownership percentage of the death benefit value. So if he owns a 1/3 interest of BizCorp, that's 1/3 of $1 million, so $333,000. And so now at death, Cal's estate is worth $1.3 million, whereas yesterday it was worth $1 million. Now, the Connelly case, it was a little skewed because we had the brothers. The one owned about 80%, the other owned about 20%. The one with 80% died, and there was, $3.8 million of life insurance that came into the business, and that added to the redemption amount. So that really skewed. It added about $1 million of estate tax liability. So this is what we need to explore. Hey, this is landmark case. In business buy-sell planning. If anybody is in any way, attached to the insurance world, you've probably heard about the implications of this decision. And there's some ways to go about, going around this, right? But the long and short of it is that, here, and I've kind of covered this, contractual obligation does not reduce the value. So the life insurance adds to the value in the estate. So business owners definitely need to carefully consider the structure of their buy-sell agreements, buy-sell plans, and life insurance policies could result in higher estate tax liabilities. Now, there's ways to avoid. First is you could disband these entity purchase agreements. You can go back to a cross-purchase agreement. Now, as we talked about that it's tough when there's a lot of owners, right? But still, that's possible, that's doable. It also is tough when there's maybe one that's not insurable and the other ones are. Well, there are also ways to go about combating that as well. Maybe the company makes larger distributions so that the policy owners can make the premium payments on that more expensive policy for the guy that smokes and drinks and is in a poor health, right? So there's ways about that. Now the other way is that using the hybrid LLC for the holding of the life insurance policies. Because, as we said, in that case, the LLC will then distribute the life insurance proceeds, and then they can turn around and buy those personally from. So we get that the both that both of the cross and entity, the best of both worlds. So there's a lot of nuance here because buy-sell agreements and funded with life insurance already in play. There's some issues with transferring ownership of life insurance policies because we want to keep life insurance income tax free, right? We want to keep that death benefit income tax free, and there could be some transfer for death, transfer for value rules that we don't want to mess around with. So this is enough. Like I said at the beginning of today, if anything, this is just spurring our clients and everyone to take a look at your business plans. If you don't have any, it's time to start. If you have some, let's take a look, see if Connelly impacts it, but let's also look at if you've got all four corners of the agreements put in place. So some best practices for you here. Number one, just, now that we know, we've seen what happened with the IRS, let's make sure that we're aligned with the IRS guidelines and consider how we're valuing our shares. Most importantly is to get a team of people together. Team of advisors, attorneys, tax advisors, financial planners, business attorneys, and everybody. Let's get them all on the same team, bring them all to the table so we can, coordinate and navigate in this process and work together to get the best plan in place. Most important is just make sure whatever is put into place is clear, that it does what you want it to do, and there's no ambiguity. There's so much ambiguity that can be built into these agreements, so it's really, really important to go through, make sure that you understand your obligations, your partners understand your obligations, so that there's no surprise, right? Other best practice, ensure proper ownership of these policies and beneficiary designations to make sure that we're going to be able to, the obligations will be fulfilled. But most importantly, is review and update these regularly. I can't tell you how often, estate planning, buy-sell planning are the same. We don't want to think about our death. And so we do it once and we think it's done. Well, times change, circumstances change. There's a family that I've worked with. I know intimately that they had a buy-sell plan in place. They had it set up so that we had one child that was a farming child and two that were not. And a long time before dad passed away, he purchased a life insurance policy on himself for a couple $100,000. And he said, well, hey, at that time, I'm going to leave my two kids that aren't farming. I'm going to leave them that life insurance policy, and I'm going to leave the farm to the child who's my farmer. Well, they didn't go back. They didn't look at that plan. And as the years went by, here's what happened. When dad passed away, the farm was worth about $10 million. And so his buy-sell agreement was never updated. And it was a one-way agreement. It was inside dad's estate plan. And so here, one child received about $10 million, and the two other children split a couple $100,000. And so even though we go through and we have the best plan in place, we need to make sure we come back to them and make sure that they're still up to date, they're still current thinking, and that the numbers and everything makes sense. So thanks for sticking around with me here today, for going through all these different buy-sell plans, what all the structures and how to do it. As I said, this is something I'm very, very passionate about, and look forward to working with anybody that would like to take me up on that offer. So Nate, I'll hand it back over to you.
Great job, Blake. Thank you for the great insights, the tangible stories that bring those to life. It's so helpful. So thanks a bunch. So there is a chat box, and so if you have a question, please type it in, and we will make sure that we cover it here, or we'll cover as many as we can in the next 5 to 7 minutes. Please join us October 24th at 10 a.m. Pacific time for our charitable giving webinar. This will be the next one in our series, so we look forward to seeing you on the other side of Labor Day, and fall will have kicked off. The leaves will be changing colors, and we look forward to talking to you again soon on charitable giving. That being said, we do have a question. So Blake, in the hybrid LLC model, how will the LLC get income or pay insurance proceeds?
Yeah, great question. And so with that, we have to find out how those policies are going to get paid through the LLC. And so typically it's going to be the LLC owners will place their own money into there to fund the LLC, or the company. Their company could make distributions into each other so that they could do that, or it could even make distributions to the LLC for that purpose. Now, when the company were to do that, it has the business owners would have to recognize that as income, because that's an income from the company that the company can't just pay the policies and not expect there to be any income tax liabilities associated with that. So one way or another, it's either the company will increase the pay for the individuals, and then the individuals will turn around and fund the LLC, or the company may skip that, go directly to the LLC. Then each individual will just have to recognize their percentage as extra income that they'll have to pay income tax on.
Great.
Yeah.
Another question. You talked about proactive business planning and estate planning.
Mm-hmm.
But at the same time, I'm not sure that they should be bifurcated when you think about your future and you think about, how these things tie together, especially as you start seeing an exit for the business and or retirement. How do you think about marrying both business planning with estate planning?
Absolutely. Without question, they need to be married together. I just can't stress that enough. But yes, and that's where, when you're crafting a buy-sell agreement, you want to have your estate plan ready to go as well, because if you've got a revocable living trust, well then your shares will be owned by your revocable trust. And so then when the cross purchase or whatever buy-sell agreement that's in place, it will be purchasing shares from your trust. And so, we just have to make sure we coordinate everything together, but I would never say you do one without the other. We need to bring both together and accomplish all the planning at one time. And then as we update, it's looking at updating both as we go forward.
Great. Well, Blake, we will end it there for the sake of time. So thank you everyone for joining us this morning or this afternoon. Blake, thank you for your insights, and we look forward to seeing you again soon in October. Have a great day.
Thanks, everyone.